most valued audience, students, uh, this is my lecture second today, and yesterday in lecture first I tried to conclude my discussion uh, with the remarks that immediately before the advent of the Islam, of course, even in customary Arabian society, the concept of marriage or institution of marriage was very much there. But the kind of the union that was known immediately before the advent of the Islam, uh, in fact, that was not a regular form of the union. That was absolutely a loose uh, form of the union, a form of the union which was totally devoid of any legal consequence, and also they were totally derogatory to the dignity and status of the women. Therefore, Islam as a mission took the serious note of all the customary marriages or sex union uh, that were prevalent at that very point of the time, and Islam as a mission decided to abrogate all form of the customary marriages or sex union that were known to the tribal Arab society immediately before the advent of the Islam. But at the same time, since institution of the marriage is a social institution, and therefore it was not possible even for the Islam to abrogate the institution. Only the format of the institution was to be reformed, was to be rectified, and therefore Islam wanted to bring the change or reform in the institution of the marriage. It never intended to abolish the institution. Rather, it intended to abolish or abrogate those form of the unions which were derogatory to the dignity and status of the women, which were totally in the loose form, the union which were totally devoid of any legal consequences, which were undurable, and therefore Islam as a mission replaced the customary form of the marriages with a regular form of the marriage or union, and accordingly all the loose form of the sex unions were replaced with a regular form of the union that is known as nikah in today or at present. Therefore, now it is necessary to explain or elaborate or clarify what is meaning and what is the definition of the word nikah or term nikah. Ladies and gentlemen, nikah is an Arabic word and literally means joining together. And when translated into the language of law, it means the union of two persons of the opposite gender. And in English term, this nikah is called as marriage. Therefore, nikah basically is a union, or it is a pact, or it is a contract or agreement between the two persons. And when this union is brought about or is established in accordance with the procedure prescribed by Muslim law, this union is called as marriage or nikah. Therefore, Holy Quran refers to the word nikah as solemn covenant or a solemn pact. That is, a pact between a man and woman who agree to lead a life together, who uh, are wishing to cohabit with each other. And when this agreement is brought about in accordance with Allah, this takes the form of the nikah, or it takes the form of the marriage. In other words, nikah is uh, wedlock, or it is mutual relation that is created by means of the marriage between a man who is called after marriage husband and a woman who is known by status as a wife after the marriage. So basically, marriage is a means, or it is a method, or it is a procedure, or it is a process whereby two persons of the opposite sex, one male and other female, they are united with each other. And once there is a formation of the union in accordance with the rules and regulation prescribed by the Muslim law, then this union of the two persons of the opposite gender, which is instituted in accordance with the legal rules and procedure, this union basically is known as nikah or Muslim marriage. Ladies and gentlemen, uh, what I have described, the concept of the marriage, or as I have tried to describe the concept of the marriage, that it is a union of the two persons which is ordinarily constituted in accordance with the procedure prescribed by the Muslim law, and it is one of the uh, solemn pact, or it is one of the solemn covenant or agreement between the two persons, whereby uh, they with their mutual free consent agree to cohabit with each other. Cohabit here means uh, they agree to live with they agree to live with each other for whole life till there is a death of either of them. Uh, on the basis of this concept, based on this concept, even the Supreme Court of India in successive judgment has clarified what is marriage in general. Because marriage is a social institution, and being a social institution, it is has been the need of every society. A society may be a religious society, society may be a secular society, society may be a political society, may be any kind of the society. Society means a composition of the human being, human society. So in every society there has been need of the marriage, and therefore almost in all the societies the basic concept of the marriage has been one and same. That may be a Hindu marriage, that may be a Muslim marriage, that may be a Christian marriage, or maybe of any other marriage of any other religious denomination. Therefore, Supreme Court uh, in general has tried to explain as to what is the marriage in general. Therefore, in Ismeda Nagpal versus State of Delhi, in 2000, the Honorable Supreme Court of India holding that held that base marriage is the basic unit of the society. It is a fundamental unit of the family, and it further observed that marriage as an institution creates most important uh, sacrosanct relation in the life of the two persons who are united with each other by means of the marriage. And it is not only the Supreme Court has also clarified that institution of the marriage or relationship created by means of the marriage is not only important in the life of two individuals who are part of the marriage, rather it goes to influence even the society at large, and not only influences the society at large, but it also creates a positive moral and social impact on the people of the society more than any other institution. Therefore, in the opinion of the Supreme Court, marriage is the basic unit of the society. It is a union of the two persons, and this union, which is brought about by means of the marriage, creates a very sacred, important, significant relation between the two persons that go to influence not only the members of the union of the marriage, but also in a larger sense impacts the life of the society itself. Therefore, it is one of the most important socio-legal institution, that is marriage, even in the opinion of the Honorable Supreme Court of India, which has been reflected upon through the successive judgments like Ismeda Nagpal versus State of Delhi and others. Uh, However, since the marriage is a socio-legal institution, socio-legal institution here means that it has social importance, because it has some social significance, in the sense that it is the primary unit of society, and a good and peaceful society is largely dependent upon the durable institution of the marriage. It is a need of the society. It is not only the need of the individual. It may be the individual, it may be the biological and social need of the individual, but marriage is also a collective need of the society, because it is the marriage which connect one person, one individual with the rest of the society. What will be the relation of one man? What will be the relation of the Mr. X with the relation of his family, as well as the society, as well as with the world at large? That is determined on the basis of the valid institution of the marriage. Therefore, Muslim marriage, not only Muslim marriage, every marriage of any society, marriage of any religion, marriage of any religious denomination, may command the social importance, because a relationship of one individual with the rest of the society is decided on the basis of the existence of the marriage. What is the relationship between a son with his father, of a man with his brothers, of a female with the males of the other family members? So all these things is decided on the, therefore it commands the social importance. At the same time, it is a legal institution also, because once a marriage is established, once a union of the marriage is formed, immediately thereafter it gives rise to various bilateral, mutual rights and obligation in favor of the parties to the marriage, that is in favor of the husband. It gives rise to certain rights. At the same time, it places certain obligation on the husband. On the other hand, after marriage, certain obligations are imposed on the wife of a marriage, and at the same time she is also put under certain legal obligations. The rights and corresponding obligations arising from the contract of the marriage, they are known as mutual spousal rights and obligations. Therefore, a marriage, including the Muslim marriage, is not only a social institution, but it is also a, it is not it is not only of religious orientation, but at the same time it is of legal effect. Therefore, this institution is called as a socio-religious, a socio-legal institution. Since it is a legal institution, therefore it is necessary that it must be defined or explained in a legal way. Therefore, various jurists of the subject of the Muslim law have formulated practical working legal definition of the word marriage or term nikah. Some of the important definitions of legal definition of the Muslim marriage which has been formulated by various jurists of the Muslim law, of the subject of the Muslim law, uh, they may be referred to here. And one of the definition of the Muslim marriage given by a well-known jurist is, that is the definition of marriage by Sir Abdul Rahim. Sir Abdul Rahim, being authority on Muslim law, he defines the marriage. And according to him, marriage is an institution, or Muhammadan jurists regard the institution. He says, Abdul Rahim says, defining the marriage, he says that Muhammadan jurists regard the institution of the marriage as partaking both of the nature of ibadat or devotional act or mamlat or dealing among men. Justice Abdul Rahim has tried to cover both the aspect of the marriage while defining it. He says that marriage is combination of the two things. It is a dealing between the two human beings. Dealing means it is an agreement between the two persons, and being the agreement, it gives rise to various reciprocal spousal rights and obligations. Therefore, it is a dealing, it is a devotional act, it is a mamlat between the two persons of the opposite gender, which is brought about by means of the marriage. At the same time, highlighting the religious aspect of the marriage, because in every society institution of the marriage has been rooted in the religion of that very particular society, in the culture of that very particular society, as it is in the case of the Muslim marriage also. So he says that Muslim marriage is not only a devotional act, not only human dealing, not only a contractual agreement, but it is also of religious nature, because the creator of the world, or creator, has himself emphasized for contracting the marriage or for establishing the union of two persons by means of the marriage. Therefore, he also says that it is a ibadat. Amir Ali, another jurist on Muslim law, he defines the Muslim marriage in a different way. He says that marriage is an institution ordained for the protection of society, and in order that human beings may guard themselves from the foulness and unchastity. Justice Mahmood, one of the noted jurists on Muslim law, he was first Indian who was elevated to the Allahabad High Court as judge. He was a very learned person of his time. He was having the command over the law, as well as the legal language. So, in a case that is known as Abdul Qadir versus Salima, basically that case was related to the nature of the Muslim marriage. That was related to the restitution of conjugal. Basically, the issue involved in the case for disposal by the court was restitution, whether the wife should be restored to the husband or not. That was the very question. But before dealing disposing of this question, Justice Mahmood tried to define what is the Muslim marriage, because without proper legal definition of the proper definition of the marriage, it could not have been proper to explain what is the nature of the Muslim marriage, whether it is a contract or it is a sacrament, whether it is combination of both, or that was not. Therefore, Justice Mahmood in Abdul Qadir versus Salima has held that nikah among the Muhammadan is not a sacrament but purely a civil contract. Uh, Therefore, in view of the uh, Holy Quran, traditions, as well as the juristic definition of juristic definition formulated by the various jurists of the Muslim marriage, it may be concluded that Muslim marriage is not merely a contract, but it is blend of both. That is, it is partly contract and it is partly sacrament. And therefore, the most suitable definition of the marriage is the definition given by Sir Abdul Rahim, who says that a Muslim marriage, according to the Muhammadan jurist, is partly ibadat and partly mamlat. Uh, uh, and therefore, it is also a devotional act. It is partly ibadat and partly mamlat, and therefore, in last we can conclude that so far as the Muslim marriage is concerned, Muslim marriage are may be defined or may be explained or may be summarized uh, in a way that it is a union, it is a legal union, or it is a union of two persons of the opposite sexes, one male and other female of consenting age. And when the formation of this union takes place in accordance with the procedure, in accordance with the due procedure and in due form, then this union takes the form of marriage, giving rise to a number of the reciprocal rights and obligations. The procedure for the formation of the union or the due form for the solemnization of the marriage that has been prescribed by the Muslim law is that there must be offer by one person, acceptance of the same by the other, and there must be it must take in the presence and hearing of the witnesses, and at the time of the marriage the parties should not be within the prohibited degree of the relation. When with these conditions two persons are united with each other, that union will be called as marriage, and that union will be a legal union, a valid union, and being a valid union, it will give rise to the number of the reciprocal rights and obligation. At the same time, it will also command the social recognition. Society will also recognize it and will recognize the status of the parties thereto. With this, now I thank all of you for today.